Well, I can really say it's a good morning today because I got the rat. I had to set a rat trap in my RV engine. So we're morning this morning for a second. Well, hey, the last video, we were reading the general orders from the Lieber Code, which is the military law review. I think that's what it's called. I'm going to go ahead and share my screen and we're going to finish reading. Let's see if this works out. Okay, can you see it? You are sharing, okay. So here we go, let me expand this. Oh, that's better. Wow, I like it. Okay, we were on page 12. Oh wait, page 13, right. So let's go ahead and just start with the top, even though I've already read from the first video, I read the beginning here. So let's start with this. This is Military Law Review, General Order 100. It's a little bit earlier today, 9 o'clock. I got to get some more liquid in my throat. I'm going to have some tea. That's good. So I will try to read this as much as I can without getting distracted. Some support for the view that it is permissible to wear the enemy uniform before the actual battle may be found in the Skorzenzi trial. In that case, a number of Germans were captured wearing American uniforms over which German parachute overalls had been hastily donned. They were acquitted because there was no evidence that they had used their weapons while disguised in American uniforms. And it also appeared that Skorzenzi had previously sought an opinion, which had advised against opening fire or committing hostile acts while in the American uniforms. The contemporary conventional rule, this is a rule for war powers and all that good stuff, is stated in Article 24 of the 1907 Hague Regulations, which provides as follows: ruses of war. Remember, they are putting on enemy outfits on top of, the German guys were putting American outfits on top of their own, and then they weren't really fighting or shooting bullets or anything, so they didn't get in trouble from that Skorzenzi trial. But ruses, this is a ruse, like a hoax and all that stuff, ruse of war, which, by the way, I remember writing up a song. I'm going to sing it. It's a ruse, it's a scam, it's a hoax, and you fell for it. It's a ruse, it's a scam, it's a hoax, and you fell for it. I knew at the beginning that it couldn't be possible, but then complicitly, everybody started to obey the orders. What does that tell us? That we've all been brainwashed to do what groupthink does. And it's a ruse, it's a scam, it's a hoax, and you fell for it. It's a ruse, it's a scam, it's a hoax, and you fell for it. It's a red herring, and it's not really true. And that was regarding COVID. Anyways, here's ruses of war and the employment of measures necessary for obtaining information about the enemy and the country are considered permissible. A general statement of today's view is that ruses of war are permissible if they do not take advantage of the protection afforded by another law of warfare. Sounds like a good disclaimer there. The examples used to demonstrate the principle in the Lieber Code are consistent with current practice. we're going to have to like look at the actual Lieber Code because this is a military review, a military law review. I gotcha. Well, we're going to look at that Lieber Code, I guess. I just realized it right now because this is the examples used to demonstrate the principle in the Lieber Code are consistent with current practice. The absence of a definition as such renders true comparison difficult. So the absence of a definition as such renders true comparison difficult. You got to have the actual definition. Measures to obtain information and ruses because of the clandestine nature of both are linked in the Hague regulations. And that's something else. That's not this. This is military law review. And that, what they're talking about right there is Hague regulations. So the usual clandestine means to obtain information is through espionage and the use of spies. That's the usual undercover means to obtain the information. So let's look at number 2, spies and espionage. Lieber deals with the subject of spies in 3 separate articles. In Article 88, a spy is defined as a person who secretly in disguise or under false pretense seeks information with the intention of communicating it to the enemy. Oh, is this kind of like that Miranda law? Anything you say can be used against you in a court of law? I think so. In the same article, the punishment of a spy is stated as death by hanging by the neck, and that this punishment is applicable whether or not the spy succeeds in obtaining the information. Ooh, wow, or conveying it to the enemy. The enemy. I mean, I'm totally thinking, you know, cops and court cases and stuff in my head. I'm not really thinking like, what's his name? James Bond and those types of enemies. I'm kind of thinking here in the United States, we are at war with this war power stuff. As defined in this article, this is an article, by the way, that we're reading, there is apparently no limitation as to locale of operations. Right, exactly. You can be on the side of the road, you can be in court, you can be at school, you can be at your house. This is in contrast with the first paragraph of Article 29 of the 1907 Hague Regulations, which states that a person may be considered a spy when acting clandestinely or on false pretenses. He obtains or endeavors to obtain information in the zone of operations of a belligerent. We should probably just look up this belligerent thing because I mean, I had some ideas of how one acts belligerent, but I just want to see what, you know, their definition of belligerent is. And probably the best way is to always go with what Black's Law Dictionary, but I'm just going to see what comes up on my phone, if anything, just to see for a second. Taking a little while. Okay. Meanwhile, I am steaming something in my Instant Pot outside. And it's in my ear. I can hear it. I'm having couscous with I don't know what that stuff is called. There's something else. Yeah, something else. I can't remember. All right, belligerent, hurry up. Come on up. Well, my phone. Let's get this going on. All right, well, whatever. I'm gonna wait until it pops up. I'm gonna keep reading. Ah, what just happened? No way! I hate it when this happens. Okay, wait. Yes, I did just get a new computer and it's not exactly showing me where stuff is. You know, like, you know, I don't exactly know where. I don't know where we are. Okay, we're on page 13, right? Yes, spies and espionage. Okay, we're over here somewhere. We were looking up, the last word was belligerent. Let me see if it happened to come up. Yes, it did. Hostile and aggressive. Right. So a nation or person engaged in war or conflict is another one, as recognized by international law. So this is what the one that they're talking about. So a nation or person engaged in war or conflict as recognized by international law. So I have a feeling this is, you know, talking about international law, but we know as people very hostile and aggressive, that's acting belligerent. But I have a feeling that because this has got to do with international law and wars, that they're really talking about a person that's in war or a nation. So here we go. In the zone of operations, that's the zone of operations of a belligerent, with the intention of communicating it to the hostile party. Is this federal manual? I'm assuming that's federal manual, but I don't know what FM is. FM radio? I don't think so. I think it's federal manual. That's what I'm guessing. 27 through 10 points out that the first paragraph of the Hague Regulation has been somewhat modified insofar as American practice is concerned by the enactment of Article 106 of the Uniform Code of Military Justice. Federal Manual 27-10 further directs that insofar as the Hague Regulation and Article 106 of the Uniform Code of Military Justice are not in conflict, they will be construed and applied together. I don't exactly know what that just meant. The Uniform Code of Military Justice and the Federal Manual together, they're not in conflict. They're going to be construed and applied together. Ugh. Otherwise, Article 106 of the Uniform Code of Military Justice. Uniform. Huh. Interesting. Will govern American practice. The British Manual in paragraph 327 states a broad definition, which is very similar to Lieber's definition, in that no mention is made of zone of operations. The British Manual then cites Hague Rule 29 and points out that an agent or spy who operates in neutral territories by sending information to one of the belligerents is not a spy within the meaning of the Hague Regulations, and gives the example of a spy operating in Tangier during World War II by observing Allied ship movements and communicating this information to one of the access nations. The comment concludes by pointing out that such an act may not amount to espionage by the law of war, although it may be so by the domestic law of certain nations. Such an act apparently would amount to espionage under the Lieber Code, since it contains no limitation as to the locale of operations, so the location. Earlier in the code, Lieber had provided that if scouts or individual soldiers disguised in the dress of the country, or in the uniform of the army hostile to their own, are found within or lurking around the lines attempting to obtain information, they are treated as spies. Like, if I had neighbors and they were acting like they were the gardener and they were dressed as gardeners and maybe using a rake, but they were just kind of spying on me, that would be spies. Or they could just be doing the gardening, I'm just saying. He states that they shall suffer death. Ooh. The Hague Regulations of 1907. Oh, there's an Article 29 with that. Clarify this principle by stating it in the converse, that soldiers not in disguise, penetrating the zone of operations, seeking information only, are not spies. So they have to be dressed up in, an opposite uniform. Yeah. Because otherwise, then they wouldn't be spied. They would just be like, that's the enemy. The enemy's right there. Yeah, they're wanting information, but it's not like they're dressed up like our side, I wonder if that has got to do with like plainclothes policemen, because they're kind of acting like they're us, but they're dressed, you know what I'm saying? I think so. That's what I think. Excuse me. In both Article 83 and Article 88, Lieber states that spies are punishable by death. Oh. But makes no mention of trial for spies. Whoa. However, it was the practice of both the Union and the Confederacy to try spies. To avoid possible abuses, it was specifically provided in Article 30 of, let's see, this is page 13, the Hague Regulations of 1907, that a spy taken in the act shall not be punished without previous trial. I gotcha. Lieber set out the rule, which is still accepted, that a successful spy, and he adds, or war traitor, right, because sometimes our guys go to other countries and they sell information. And if you're in a war, then that would be considered war traitor. Who, after safely rejoining his own army, is captured by the enemy, is immune from punishment for his acts as a spy or war traitor. Looking at the present law and comparing it, what just happened? Geez, go back. I hate it when this happens. Okay, I was just going over here. Touchy. Okay, so looking at the present law and comparing it with the Lieber Code reveals almost no real change in the rules governing spies and espionage. On the other hand, there has been a big change in espionage efforts of the major powers. Peacetime espionage has become big business, involving the expenditure of millions. The Hague Regulations of 1907 apply only in time of war. So that's the Hague Regulations of 1907. They apply only in time of war. And modern, well, I mean, come on, when's not a time of war? Because aren't we in a perpetual war? War on drugs, war on terrorism, war on COVID. Come on. I'm kind of thinking that's applying all now. The Hague Regulations of 1907 apply only in time of war. And modern nations seem satisfied to leave peacetime espionage unregulated by international legislation. The territorial qualification inserted in the 1907 Hague Regulations has not prevented a belligerent from punishing those who commit acts of espionage in other areas. The nebulous term of war treason, isn't nebulous kind of like pertaining to like nothingness out there? The nothingness up in fake space term war treason is generally used to describe, among other things, acts of espionage committed outside the zone of operations of a belligerent. This then brings us to a discussion of war treason under the Lieber Code. Here we go, war treason, number 3. The term war treason, in the sense in which it is now understood in international law, was first used in the Lieber Code. Lieber's Article 90 contained his basic definition of war treason. So down here, let's see, this article contains an excellent detailed discussion of Lieber's development of the concept. A traitor under the law of war, or a war traitor, is a person in a place or district. My dog went, okay. My dog's on my side. My neighbor's dog is on my side, and they're playing, and I don't have a problem with that. Apparently he does. So he's yelling. Okay, so I got distracted. That was a distraction for sure. A traitor under the law of war, or war traitor, is a person in a place or district under martial law who, unauthorized by the military commander, gives information of any kind to the enemy or holds intercourse with him. You know, an exchange of information type of thing. As was usual, Lieber includes information relative to the punishment which might be imposed. It was provided that the punishment for the war traitor is always severe, and if it involves betrayal of information concerning the condition, safety, operations, or plans of the troops holding or occupying the place or district, his punishment is death. The offenses encompassed in the term war treason are spelled out in several other articles of the Lieber Code. If the inhabitant of an occupied area gives information to his own government or army, he is a war traitor. Okay, let me just read that again. If the inhabitant of an occupied area gives information to his own government or army, he is a war traitor. Conversely, voluntary service as a guide to the enemy by a citizen of a hostile and invaded district is also deemed to be war treason. Article 98 characterizes all unauthorized or secret communication with the enemy. That's kind of reminding me of ex parte communications right here, as treasonable by the law of war. And Article 104 refers to the war traitor who has safely returned to his own army. We cannot have any ex parte communications with you. You need to go to the judge. You cannot go above their head because the judge can't, whatever. So I just made that up. That was just in my little letter that I had received. The logical conclusion from a study of all these articles is that the offense of war treason under Lieber's view could take place only in occupied or invaded territory. We're occupied. US is a corporation, and they are occupying over here in our areas. I mean, come on. Federal government is 10 by 10 square miles, and they are occupying, just like they occupied Hawaii, and they invaded their territory, because they're occupied. But then they go and make them, let's do some paperwork, and we'll make you one of the states. Well, those people, Queen, King Kamehameha, they were held by rifle point. Sign that paper. So the US corporation went and invaded. They invaded Hawaii, the islands, the Hawaiian kingdom. They're doing the same thing here with us too. Yep, it's true because we're on the land. And so right here, this is under Lieber's view, could take place only in occupied or invaded territory. In summary, under the concept of the Lieber Code, my voice was just echoing in this thing. I got this fun thing. I know, I'm being distracted. I have the little sticks. I was just hearing my voice in there. Where am I? I got distracted. Okay. In summary, under the concept of the Lieber Code, the war traitor is a civilian inhabitant of occupied territory who gives information to or holds intercourse with the enemy. The war traitor is not to be confused with the war rebel, later discussed, who is a civilian inhabitant of occupied territory who commits hostile acts against the occupying power. Like you got those people, those little kids that throw rocks. That's what reminds me of when we go and invade their country, or at least when the United States Corporation goes and invades their country. Then the little kids are throwing rocks at the guys. Or with the spy who acts clandestinely or under false pretenses in committing acts of espionage. This distinction has not been so clearly drawn in international law outside of the Lieber Code. The term has been very loosely used to encompass hostile acts, as well as the conveying of intelligence or information. It is clear, however, that enemy soldiers, unlike private individuals, may be punished for such acts only when they commit them within an enemy's lines while in disguise. Today, the term war treason and its concept has fallen into disuse. The term does not appear at all in the 159 articles of the 1949 Geneva Civilian Convention. Undoubtedly, the reason is that the word treason implies a breach of allegiance. And it is emphasized in the Civilian Convention that the inhabitant of occupied territory is not bound to the occupying power. That sounds interesting. Oh, okay, let me just see. The reason that the word treason that the word treason, undoubtedly, the reason is that the word treason implies a breach of allegiance. And it is emphasized in the Civilian Convention that the inhabitant of occupied territory is not bound to the occupying power by any duty of allegiance. Well, that's awesome. So, hey, if the United States federal government is occupying our area, saying that they're claiming territory or our land or us, I'm not down with them doing that. It says that we're not bound to the occupying power by any duty of allegiance. That's awesome. Yes, that's cool. Hey. Well, that's great news to me. Yeah, because I don't want them claiming my land. My body is land. I'm not down with that. So yeah, that's cool. I like this one right here on page 16 on the top left. That's a good one. Woohoo! The nearest modern counterpart to Lieber's war treason in international law is contained in Articles 64 to 68 of the 1949 Geneva Civilian Convention. Under this convention, the occupying power may enact criminal laws That's what they're doing in courts. That's what they're doing in traffic court. Right here. That's what they're doing. They're enacting criminal laws. Like you had a private plate and you didn't register it. So we're going to make you a criminal. So they're doing that under the Geneva Civilian Convention. Interesting. Okay, I'm reading into this, but let's see if this is what that really means. I could be wrong. Under this convention, the occupying power may enact criminal laws which must be duly published and which must not be retroactive to ensure the orderly government of the country and the security and needs of the army of occupation. These laws may be administered by non-political military courts sitting in the occupied territory. I guess we'd have to find out if these courts are seated, you know, if these particular courts, like, you know, in your county are seated under the federal government. Although courts of appeal may sit elsewhere. Get that? Interesting. This is a good one right here. The death penalty? That doesn't sound good. The death penalty, the death penalty may be imposed on a civilian inhabitant only where he is guilty of espionage, or serious acts of sabotage against military installations of the occupant, or of intentionally causing death. Oh, okay. However, such offenses must have been punishable by death under the law of the occupied territory prior to occupation. What just happened? What just happened? I think I skipped pages. There we go. We're on page 16. Yeah, here we go. Okay, good. Whew. Man, I tell you, my little mouse is, I'm talking about my computer mouse now. It's so touchy. Sheesh. Okay, so here we are. I want to follow with this little arrow so we can see where I'm reading. And the attention of the court must be drawn to the fact that the accused does not owe any duty of allegiance to the occupant. That's kind of good. In no case can a protected person, hey, right there, be given the death penalty if he was under 18 years of age at the time of the offense. Okay, so those little kids that are in another country throwing rocks, they're okay and protected. For most offenses other than those discussed herein, the punishment may be only internment or simple imprisonment. Is that simple? It would seem that Lieber's offense of war treason, since it falls outside the commonly accepted definition of espionage, with its requirement of clandestine activity, would be treated as one of these non-capital crimes. The only possible exception may be if the action constitutes a grave collective danger. Under Article 68. The offense of war treason, although not so termed, survives in the municipal law of the United States. The offense of war treason, although not so termed, survives in the municipal law of the United States. You know, municipal law. Oh. Paragraph 185 of the manual for courts martial, United States, 1951, provides inter alia as follows. A person living in occupied territory. A person, which is that ens legis corporation, all capitalized name, living in occupied territory, who without dissimulation merely reports what he sees or what he hears through agents to the enemy, may be charged under Article 104 of the Uniform Code of Military Justice with giving intelligence to or communicating with the enemy. That's interesting. Whoa. So I wonder if those guys, those FBI guys, if they ever came to you, you know, and if you tell them the stuff that you know, that would be communicating with the enemy, I would think. Anyways, but he may not be charged under this article with being a spy, right? They just want to know what you know. Okay, in Federal Manual 2710, I'm assuming that's Federal Manual, it doesn't say. The only reference to war treason is in the index where it says see espionage, sabotage, and treason. Ultimately, the reader is referred to paragraph 79 on page 33, which merely quotes Article 104 of the Uniform Code of Military Justice, which deals with aiding the enemy and gives a brief interpretation. It is indicated that cases occurring in the United States outside military jurisdiction are triable by the civil courts under the espionage laws and the laws relating to treason. Many articles of the Lieber Code deal with the problem of hostile activities on the part of enemy citizens not in uniform. In addition to the war traitor who did not take up arms but dealt only in information, others took an active role and became what might be termed irregular combatants. To distinguish them from the regular forces. Interesting. Irregular warfare. Number 4. Section 4 of the Lieber Code, which might have been entitled the irregular combatant, dealt with the subjects of partisans, armed enemies not belonging to the hostile army, scouts, armed prowlers, and war rebels. Historically, this section of the code, for the most part, can be traced to a pamphlet entitled Guerrilla Parties, Considered with Reference to the Laws and Usages of War, written by Lieber in August of 1862 at the request of Major General Henry W. Halleck, then General-in-Chief of the United States Army. The reason for such a pamphlet is best explained by the letter from Halleck to Lieber requesting it. Halleck stated that the rebel authorities claimed the right to send men in the garb of peaceful citizens to waylay and attack our troops, to burn bridges and houses, and to destroy property and persons within our lines. They demand that such persons be treated as ordinary belligerents, and that when captured, they have extended to them the same rights as other prisoners of war. They also threaten that if such persons be punished as marauders and spies, they will retaliate by executing our prisoners of war in their possession. Oh. In practical effect, this is page 18, the Lieber Code divided irregular combatants into 2 categories. The first of these, his so-called partisan, was entitled to the status of a prisoner of war, The second category embraced everyone who, although not a regular soldier, a partisan, or a member of Levian mass, nevertheless committed hostile acts against the invading or occupying army. The first article of section 4 defines the term partisan. In guerrilla parties, Lieber had stated that this is a term which is vaguely used, and so in the instructions he attempts to attach a limiting definition to the effect that partisans are soldiers, armed and wearing the uniform of their army, but that they belong to a corps which is detached from the main army for the purpose of making inroads into the territory occupied by the enemy. These partisans, if captured, are entitled to the privileges of a prisoner of war. In guerrilla parties, Lieber spoke more broadly, saying that partisans are entitled to the privileges of the law of war, so long as they do not transgress it themselves. To transgress means to cross over a boundary. Don't transgress, don't tread on me. The reason for Lieber's careful definition, including the requirements of being soldiers, armed and wearing the uniform of their army, becomes apparent when some of the succeeding articles are considered. For example, Article 82 provides men or squads of men who commit hostilities, whether by fighting or inroads for destruction or plunder, or by raids of any kind, without commission, without being part and portion of the organized hostile army, and without sharing continuously in the war, but do so with intermitting returns to their homes and avocations, or with the occasional assumption of the semblance of peaceful pursuits, divesting themselves of the character or appearance of soldiers. Such men or squads of men are not public enemies, and therefore, if captured, are not entitled to the privileges of prisoners of war, but shall be treated similarly as highway robbers or pirates. Okay. That's like Robin Hood and his merry men. Then Lieber adds Article 84, which defines armed prowlers in terms of their activities. He says that whatever you call them, persons of the enemy's territory who steal within the lines of the hostile army to, number one, rob, kill, or destroy. That sounds like Satan. Satan comes to rob, steal, and destroy. Or rob, kill, and destroy. Bridges, roads, or canals. Rob or destroy the mail, or cut telegraph wires. What about EMF attacks? Are not entitled to be treated as prisoners of war. Interesting. Aside from the robbery and the killing of persons unconnected with the war effort, it would seem that all of these activities are legitimate ones for the partisan, as he defines them. In fact, in guerrilla parties, Lieber points out that the partisan acts chiefly upon the enemy's lines of connection and communication. Undoubtedly, Lieber meant to exclude partisans from Article 82 by means of his carefully worded definition of partisans, and by merely referring to persons of the enemy's territory in Article 84. So he is purposely defining and partitioning the different partisans. So within section 4, Lieber defines another category of persons who are deemed to be beyond the pale and not entitled to be considered prisoners of war. This is his so-called war rebel. War rebels are persons within an occupied territory who rise in arms against the occupying or conquering army. Or against the authorities, established by the same. Whoa. If captured, they may suffer death, whether they rise singly, in small or large bands, and whether called upon to do so by their own but expelled government or not. They are not prisoners of war. I'm all thinking about the Waco, Texas thing and that Davidian branch, you know. I think they were calling them war rebels. Nor, excuse me, nor are they, if discovered and secured, before their conspiracy has matured to an actual rising or armed violence. Yeah, because they went in there with tanks. Oh, we got to save the children, and then they killed them all. Now that's perfidy right there. This is based on the concept that the inhabitant of occupied territory owes a certain allegiance to the occupier and has a duty to terminate his resistance when occupancy has become an actual fact. This is something that's interesting here. However, as in the case of the war trader, it is clear that today the civilian inhabitant of occupied territory owes no such allegiance to the occupying power. What does that mean? However, as in the case of the war trader, it is clear that today the civilian inhabitant of occupied territory owes no such allegiance to the occupying power. The rules regarding irregular combatants, but not the terminology, set out by Lieber are in fair accord with the discussion contained in the Federal Manual 27 through 10. We're going to have to read that. Paragraphs 80 through 82. I'll have to look that up in another video. Through the years, the so-called guerrillas, partisans, and franksterers and others who engage in combat against an enemy. Oh, this is those who engage in combat against the enemy. Don't be punching that policeman. In front of or behind his lines without meeting the qualifications of lawful combatant have not been accorded the status of prisoner of war. That's why. A problem area in international law has been the treatment of these people, whether as war criminals or merely as persons whose acts have been harmful to the opposing belligerent. It was generally understood before 1949 that such persons were subject to the death penalty, and that was about the only clear part of the law in this regard. And keep in mind, I'm actually reading this and trying to see between the lines here to see if this is pertaining to us, because I think it does. I think there's double speak in here. And I'm just trying to see, you know, how does this apply to us? Because this sounds like it's very far removed somewhere else, but I don't think so. I think it's here. In 1949, even though that was way back when, the law was clarified in this area by the Geneva Conventions. Under Article 4 of the 1949 Geneva Prisoner of War Convention, members of militias, volunteer corps, or resistance movements. Ooh, can you say AVR? Resistance movements who comply with the requirements that they be commanded by a responsible person, wear a fixed distinctive sign, carry arms openly, and comply with the laws of war, are even in occupied areas entitled to be treated as prisoners of war if they are captured. I wonder if the policemen, know about this kind of stuff, and if they're actually going by this kind of rule book. I wonder. Thus, Lieber's war rebel or any other irregular combatant could gain prisoner of war status upon capture if they complied with these 4 requirements that were here: that they be commanded by a responsible person, wear a fixed distinctive sign, like, a uniform or a badge, or maybe even on their car, carry arms openly. I got arms. Are they talking about these arms, or are they talking about military? Yeah, I think so. I don't know, maybe they could say that because I'm carrying my arms and comply with the laws of war are even in occupied areas. I just think that's funny that they call weapons arms. I mean, these are my arms right here, just saying. They could be used as weapon. They use their arms as weapons. I'm just saying. Thus, Lieber's war rebel or any other irregular combatant would gain prisoner of war status upon capture if they complied with these 4 requirements that I just read twice. However, the usual secretive nature of such groups makes compliance with these 4 requirements, particularly the use of distinctive insignia and the open bearing of arm, now it's 1 arm, very unlikely. Oh, I see. I gotcha. Also, although not a war crime, their hostile acts will usually be a capital offense against occupation law as set out in Article 68. I wonder if this has got to do with those people that stormed the Capitol. What just happened? Okay, so this being true, these people are left with only the procedural and general safeguards afforded by the Civilian Convention. Oh, is that why you want to ask for civilian due process? Because they have you under military occupation and they're considering you a combatant? So they're doing a, what is it, military admiralty law tribunals, and you want to say, can I have civilian due process, please? Oh, that would be a good thing to say, I guess, if it takes a turn for the worse. While discussing the subject of irregular combatants, it is logical to raise the question regarding the status of the uniformed, not uninformed, it's uniformed, United States Army Special Forces soldier who aids and advises guerrilla groups. As a uniformed soldier, he is entitled to prisoner of war status and is not amenable to trial for his acts unless he has committed a war crime. He is not guilty as an aider or abettor to a war crime, because the hostile acts of the guerrillas are not war crimes, but only violations of occupation law. Very interesting. That's kind of interesting how they're using occupation law. Like occupation can be, construed as, what is your occupation? I'm a doctor, I'm a lawyer, I'm a hairdresser. Like commercial, commerce. I wonder if that's what they're kind of saying, violations. Like, you walk into Sprouts and you say, I'm not going to wear a mask. And they're like, this is our rule. And then, they get you on trespass for their corporation. I don't know if this occupation law, I know it's concerning, we are occupying the, like, how the United States corporation takes all their people, all those volunteer people who want to think that they're fighting for their country, but they're really fighting for the US corporation, and they put them over in Serbia or some other place. And they're occupying the territory. I know that's what they're saying here, but I just thought occupation, kind of interesting that they use that word. As has been pointed out, guerrilla activities have become increasingly important, both in international conflicts and conflicts of less than international character. Both the Lieber Code and in today's practice, the rules are principally directed toward protecting the uniformed combatant in the event of capture. Lieber's rules were drafted during and were first used in a civil war. In this application, his rules are somewhat reflected in the common Article 3 of the 1949 Geneva Conventions, governing conflicts of less than international character. This provision, of course, is not applicable to conflicts between states. That's interesting. What about an all capitalized state? In these conflicts, Articles 64 through 71 of the 1949 Geneva Civilian Convention have contributed significantly to the control of anti-guerrilla operations. Guerrillas may still be punished, as in Lieber's day, but only through the judicial safeguards recognized by civilized nations, which through this convention have been internationally codified or codified. They put codes on them. Throughout the discussion of irregular combatants, the rule emerges that both under the Lieber Code and under today's rules, the uniformed combatant, as opposed to the combatant not in uniform, is permitted to commit hostile acts behind enemy lines or in occupied territory, and is entitled to prisoner of war status. As a prisoner of war, he is immune from punishment for his hostile acts, unless they are war crimes. Interesting. A prisoner of war is immune from punishment for his hostile acts. I wonder if, if you took off your license plate off your car and put on a private plate, would that be considered a hostile act? Because you gave your car to the corporation, which pretended to be your state, which it's not the land, it's a corporation. I wonder if that would be considered a prisoner of war. Maybe. Hey, I'm immune from punishment for changing my license plate. and taking back my car that I paid for, that you should have paid for because it's really registered to you. That's your debt. I think you need to discharge my car. Let me see. 1099 OID, original issuer discount. I think so. 1099A. I'm gonna have to put a claim on that. I'm gonna have to do that to my whole car. 1099A means, acquisition or abandonment of property. Okay, so back to this. This rule also seems to apply to another practice. Oh, does it now? Generally carried out behind the enemy lines or in occupied territory. Assassination. Oh, that doesn't sound good. Assassination and outlawry. Assassination is the subject of the single article, which makes up section 9 of the Lieber Code. X is a 10, and they put a 1 in front of the 10. That means it's a 9 of the Lieber Code. This article provides as follows: the law of war does not allow proclaiming either an individual belonging to the hostile army, or a citizen, or a subject of the hostile government, an outlaw who may be slain without trial by any captor, any more than the modern law of peace allows such intentional outlawry. On the contrary, it abhors such outrage. The sternest retaliation should follow the murder committed in consequence of such proclamation made by whatever authority. Put your hands up. Throw your weapons. And just go and kill people. Civilized nations look with horror upon offers of rewards for the assassination of enemies as relapses into barbarism. Barbarism. What do they got, those guys that go bounty hunters? I guess if they, killed them, then hello. Well, if they wanted dead or alive, I guess that would be all right. But I'm just saying. During and prior to Lieber's time, writers emphasize that assassination must not be confused with surprises. Good, because I don't like surprises. Which were considered lawful. Oh, surprises were defined as the act of an individual soldier or of a small detachment of soldiers who penetrate the enemy lines in order to kill the enemy general or other leaders. You want a surprise? Yeah. No, I don't want a surprise. It is said that this is permissible because such acts lack the disguise or treachery, which gives the deed the character of murder or assassination. The prohibition, then, was against the assassination of an individual by those in disguise or not in uniform. I'll tell you. In disguise. Okay, so O.J. Simpson was not in disguise. He was not in uniform. But you know what happened. If the glove doesn't fit, you shall acquit. Okay, so, and against seeking such action by proclaiming an individual an outlaw, subject to being killed without trial. So let me read this again. It is said that this is permissible. What? Surprises? Surprises. Surprises is permissible. Because you're not, it's not like you're wearing, a uniform or, wait a minute. Let me run and understand this again. Surprises were defined as the act of an individual soldier, okay, you had to be in uniform, or of a small detachment of soldiers who penetrated the enemy lines in order to kill the enemy general or other leaders. So these ones here had already had, military outfits on. It is said that this surprise stuff is permissible because such acts lack the disguise. It's not like they were wearing someone else's uniform on the other side, or treachery, which gives the deed the character of murder or assassination. Come on, get real. The prohibition, then, was against the assassination of an individual by those in disguise or not in uniform. Don't get that. The prohibition, meaning you're not allowed to do this, was against the assassination of an individual by those in disguise or not in uniform and against seeking such action by proclaiming an individual an outlaw subject to being killed without trial. Boy, I tell you, there's so many twists and turns. It's difficult to understand that. Maybe the more we read it, it will be more clear. So they're talking about this thing called surprises. You're not really surprised when someone's wearing a uniform, right? You're surprised when they're your friend and they're not wearing a uniform. It is said that this is permissible because such acts lack the disguise or treachery. It is said that this is permissible. Oh, what? Assassination is permissible? You can assassinate people when you have a uniform on, but you can't assassinate people when you don't have a uniform on. So I'm trying to figure out. Oh man, you gotta read it. Surprises were defined as the act of an individual soldier or of a small detachment of soldiers who penetrate the enemy lines in order to kill the enemy general or other leaders. It is said that this is permissible because such acts lack the disguise or treachery, which gives the deed, right, the character, right. Because if you're disguised, it gives the deed of murder or assassination. The prohibition then was against the assassination of an individual by those in disguise or not in uniform, right? I got that. And against seeking such action by proclaiming an individual an outlaw subject to being killed without trial. So many twists and turns with these rules. So, okay, let's see. Page 22. The prohibition was carried over into the Hague Regulations of 1899 in 1907 in the form of a brief statement that it is forbidden to kill or wound treacherously individuals belonging to the hostile nation or army. Federal Manual 27-10 construes this article as prohibiting assassination, proscription, or outlawry of an enemy, putting a price on an enemy's head, or offering a reward for an enemy dead or alive. That's like what they would do with the bounty hunters, wanted dead or alive. However, it is indicated that it does not preclude attacks on individual soldiers or officers of the enemy, no matter where they are located. I hate it when they do that. However, it is indicated that it does not preclude attacks on individual soldiers or officers of the enemy, no matter where they are located. The British Manual deals with assassination extensively. Paragraph 115, inter alia, recites the prohibition of the Hague regulations, and paragraph 116 reflects the language of the U.S. Army Field Manual in regard to outlawry and the offer of rewards. However, in paragraph 115, the prohibition, meaning you can't do that, against assassination is expanded and spelled out in some detail. It is stated that the killing or wounding of a selected individual behind the line of battle by enemy agents or partisans is not a lawful act of war. The example is given of the assassination of Heydrich, the German civilian governor of Bohemia Moravia, by Czech partisans in 1942. It is pointed out that the perpetrators could have been tried as war criminals. Unable to trace the offenders, the Germans killed the inhabitants of Lidice and destroyed the town. Yikes. The comment is made that whereas the latter act may at that time have been justifiable as an act of reprisal, the killing of the inhabitants was not, and it was rightly labeled as a brutal massacre by the International Military Tribunal. Just like what happened in Waco. That was a terrible, brutal massacre. I can't believe that they did that to those people. The British Manual also states that under this prohibition, it is not forbidden to send a detachment or individual soldiers to kill by sudden attack a member or members of the enemy armed forces. The example is given of the raid by British commandos on General Rommel's headquarters at Beta Litoria in 1943. In regard to the prohibition against outlawry, putting a price on the head of an enemy, and the offering of dead or alive rewards, the British Manual raises a question which is very pertinent during this period of uprisings and irregular warfare, and that is how far do these rules apply to armed conflicts, not of an international character occurring in the territory of a state? In the territory of a state, question mark? The answer clearly seems to be that these rules do not apply except as an aid to construing Article 3 of the 1949 Geneva Conventions. So we're on page 23. So we went from page 13 to 23. This is 10 pages. We'll finish here. And then if we get cut off, well, that'll be the end of the video. Okay, so once again, this is General Order 100. It's a military law review of the Lieber Code. The common Article 3 of the 4 1949 Geneva Conventions sets out the acts which are prohibited in conflicts of less than international character. Paragraph 1A of that article forbids murder of all kinds. That's good. In respect to persons who take no active part in the hostilities, those who are hors de combat, and those who have laid down their arms. The probable effect of the common Article 3, when applicable, is to prohibit inducements being given for troops, police, or civilians to take the law into their own hands. Right here. In summary, the rules regarding assassination and outlawry have not changed substantially through the years, and the rule of the Lieber Code is still current. Selective killing by the guerrilla remains a war crime, but the uniformed soldier may commit such acts with impunity. However, governments may not declare an individual an outlaw and place a price on his head. That's good to know. The basis of prohibiting assassination is its treacherous nature, and likewise the use of poison traditionally has been prohibited because of its treacherous nature. An additional basis of the prohibition against poison has been that it would cause unnecessary suffering. Let me see, poison, would that be like, stuff they put in the water like fluoride? Would it be chemtrails with aluminum, barium, strontium, and lithium? Are they giving us a little bit of time? They're spraying it on us. Yeah, hello. Number 6, right to prisoner of war status. Article 49 of the Code defines a prisoner of war as a public enemy who is armed or attached to a hostile army for active aid and who is captured in any way. Then the following categories of personnel who may be prisoners of war are set forth: soldiers of whatever species of arms, members of a rising in mass, all those who are attached to the army for its efficiency and promote directly the object of the war, with certain exceptions later discussed. D, disabled men and officers. E, enemies who have thrown away their arms and asked for quarter. There's that word again, quarter. I don't think it's 25 cents, so I'm pretty sure it's got to do with like housing. I don't know. Let me see. Quarter. I want a safe spot. Let me see. Enemies who have thrown away their arms and asked for quarter. All right, come on, phone. What am I using? Bing or Google? Don't know. They asked for quarter. I'm assuming that it's a place of safety. Well, it'll come up in a second. But meanwhile, I'm going to keep reading. Oh, here it is, quarter. Of course, they put a quarter. No. Oh, no. Okay, a part of a town or city having a specific character or use. Each of 4 equal or corresponding parts into which something is or can be divided. Yeah, like a quarter. 1/4 of a pound. Don't think it's that one. The haunches or hindquarters of a horse. I don't think it's that one. It's got to be the part of a town or city having a specific character or use. It is a beautiful port city with a fascinating medieval quarter. Verb. Oh, here. It's to be stationed or lodged in a specific place. That's what I think it is. Yeah. Hey, display different coats of arms in quarters of a shield. Oh, especially to show arms inherited from heiresses who have married into the bear's family. That's under heraldry, but so I think that they mean quarter to be stationed or lodged in specific places. Many were quartered in tents. Yeah. So that's what the enemies who have thrown away their arms and asked for quarter. Can I be in that cage over there, please? So F, citizens who accompany an army for any purpose, such as sutlers, editors, reporters, or contractors. Let me just look if there's a little bit more left. We'll finish this. G, the monarch, his family, principal officers, and diplomatic agents of the hostile nation, and H, partisans. There's that word again. Partisans. Partisans were those military type of guys that were really not part of the whole. They were part over there. Under present practice, Lieber's term soldiers of whatever species of arms has been expanded to mean members of the armed forces, and the fact that it includes militias and volunteer corps when part of the armed forces has been spelled out. The rising in mass is now covered by paragraph A6 of Article 4 of the Geneva Prisoner of War Convention. Persons accompanying the armed forces are also covered. Disabled men and officers is a category equivalent to Article 14 of the 1949 Geneva Convention for the amelioration of the condition of the wounded and sick in armed forces in the field. Lieber's classification of enemies who have thrown away their arms and asked for quarter is merely cumulative to his first category of soldiers. In today's practice, civilian ships, crews, and aircraft crews are entitled to prisoner of war status unless they can get favorable treatment under other provisions in international law. Oh, in today's practice, civilian ships, you mean like if you're going on a cruise? Oh, maybe the people that are the crew of the cruise ship. That's probably in today's practice, civilian ships cruise, not a cruise ship, but the people who work on the cruise ship. And aircraft crews, the stewardess, the airline pilot, are entitled to prisoner of war status unless they can get more favorable treatment under other provisions. Let me see. So unless they can get more favorable treatment under other provisions of international law. So they probably don't want to be a, what is it called? Prisoner of war. I wanted more favorable treatment than this prisoner of war thing. So you'd have to find out what that is. The second paragraph of Lieber's Article 50 relating to the monarch, his family, principal officers, and diplomatic agents and others has no exact parallel in either the Hague Regulations or the Geneva Prisoner of War Convention. Senior enemy officials do not become prisoners of war upon capture by the armed forces. However, if military security makes it absolutely necessary, such persons may be put in assigned residences or interned as protected persons under the Geneva Civilian Convention. If senior enemy officials accompany the armed forces and fit into the category outlined in Article 4A4 of the Geneva Prisoner of War Convention, they are entitled, this is what you're entitled to, prisoner of war status upon capture. Heads of state often are the commander-in-chief of the armed forces and thus entitled to prisoner of war status under Article 4.1a of the Geneva Prisoner of War Convention. Of course, the enumeration of categories in Article 4 is not exhaustive, and a belligerent could extend POW, prisoner of war status, to persons other than those listed. Historically, one of the most difficult questions to be solved has been that of treatment of applicable to partisans or guerrillas. It has been said that the Brussels Conference of 1874 failed in its attempt to codify the laws of war. They didn't put codes on them because of the impossibility of agreement on the question of partisans. As pointed out elsewhere in this article, Lieber set up strict standards in this regard. His definition of partisans limited it to soldiers armed and wearing the uniform of their army. And said that they were merely detached from the main body to make inroads into the territory occupied by the enemy. So if there's a battalion and then there's some squads, and then this one squad is over here, you guys go make some inroads over there, but here's that whole battalion thing, then this one's the partisan, this squad over here, or a few people, or one person. They would be the ones that go chop down all the bamboo, or, you know, whatever. Go make some inroads so we can get in there. These people, he said, were entitled to prisoner of war status. Non-uniformed guerrillas, not being part of the organized army, were flatly denied prisoner of war status. Also, under the prevalent concept that the inhabitants of occupied territory owed a duty of obedience to the belligerent occupant, members of resistant movements in occupied areas were not entitled to prisoner of war status. So what was that? Also, under the prevalent concept that the inhabitants, the people who live there, of occupied territory, let's say Hawaii, let's say the United States military occupied Hawaii, which is what they really did around Pearl Harbor time, and they're still there today. And those people that live there in Hawaii, okay, under the prevalent concept that the inhabitants of occupied territory owed a duty of obedience to the belligerent occupant. Are you an American citizen or are you a United States citizen? Members of resistance movements like the Hawaiian Kingdom in occupied areas were not entitled to prisoner of war status. Yeah, especially when they say, hey, Hawaii, you're part of the United States. Do we have to? Yeah, we signed a contract. Yeah, remember that rifle pointed at Queen Kamehameha and the king? Mm-hmm. And they never fixed that paperwork. The concept of the rising in mass has not been extended since Lieber's day to include these people, even though they are the only people who really rise. The old levy in mass rarely, if ever, occurs. All right, so we're going to stop right here, page 25. We're going to start with this question on the next video. So we did a little bit more reading and we got further than the last time. So I got to learn how to turn this off because I don't know how to do it. All right, stop, pause, stop.